Cohen also said he did not tell the president about the specific of his planned testimony. During the time when his statement to Congress was being drafted and circulated to members of the JOA, Cohen did not speak directly to the president about the statement, but rather communicated with the president's personal counsel as collaborated by phone records showing extensive in his discussions with the president's personal counsel on August 27, 2017. The day before Cohen's statement was submitted to Congress, Cohen said that there were more communications with Russia and more communications with candidate Trump than the statement reflected. Cohen recalled expressing some concern at that time. According to Cohen, the president's personal counsel, who did not have firsthand knowledge of the project, responded by saying that there was no need to muddy the water, that it was unnecessary to include these details because the project did not take place, and that Cohen should keep his statement short and tight, not elaborate, stay on message, and not contradict the president. Cohen's recollection of the content of these conversations is consistent with direction about the substance of Cohen's draft statement that appeared to come from members of the JOA. For example, Cohen omitted any reference to his outreach to Russia's government officials to set up a meeting between Trump and Putin during the United Nations General Assembly, and Cohen believed it was a decision of the JOA to delete the sentence. Quote, "The building project led me to make limited contacts with Russian government officials," end quote. The president's personal counsel declined to provide us with his account of the conversations with Cohen, and there is no evidence available to us that indicates that the president was aware of the information Cohen provided to the president's personal counsel. The president's conversations with his personal counsel were presumably protected by attorney-client privilege, and we did not seek to obtain the contents of any such communications. The absence of evidence about the president and his counsel conversations about the drafting of Cohen's statement precludes us from assessing that, if any, role the president played. Number 2. Thank you.
I'm Judy Pye. I'm an actress and art consultant. Second, we considered whether the president took actions that would have had the natural tendency to prevent Cohen from providing truthful information to criminal investigators or to Congress. Before Cohen began to cooperate with the government, the president publicly and privately urged Cohen to stay on message and not flip. Cohen recalled the president's personal counsel telling him that he would be protected so long as he did not go rogue. In the days and weeks that followed the April 2018 searches of Cohen's home and offices, the president told reporters that Cohen was a good man and said he was a fine person from a wonderful family who I have always liked and respected. Privately, the president told Cohen to hang in there and stay strong. People who were close to both Cohen and the president passed messages to Cohen that the president loves you, the boss loves you, and everyone knows the boss has your back. Through the president's personal counsel, the president also had previously said Cohen thanks you for what you do after Cohen provided information to the media about payments to women that, according to Cohen, both Cohen and the president knew was false. At the time, the Trump Organization continued to pay Cohen's legal fees, which was important to Cohen. Cohen also recalled discussing the possibility of a pardon with the president's personal counsel, who told him to stay on message and everything would be fine. The president indicated in his public statements that a pardon had not been ruled out, and also stated publicly that, quote, most people will flip if the government lets them out of trouble, but that he didn't see Michael doing that. After it was reported that Cohn intended to cooperate with the government, however, the president accused Cohn of, quote, making up stories in order to get himself out of an unrelated jam. Taxi cabs, maybe? He called Cohn a rat and on multiple occasions publicly suggested that Cohn's family members had committed crimes. The evidence concerning the sequence of events could support an inference that the president used inducements in the form of positive messages in an effort to get Cohn not to cooperate, and then turned to attacks and intimidation to deter the provision of information or undermine Cohn's credibility once Cohn began cooperating. B. Nexus to an official proceeding. The president's relevant conduct towards Cohn occurred when the president knew the special counsel's office, Congress, and the U.S. Attorney's Office for the Southern District of New York were investigating Cohn's conduct. The president acknowledged through his public statements and tweets that Cohn potentially could cooperate with the government investigations. C. Intent. In analyzing the president's intent in his actions towards Cohn as a potential witness, there is evidence that could support the inference that the president intended to discourage Cohn from cooperating with the government because Cohn's information would shed adverse light on the president's campaign period, conduct, and statements. Cohn's false congressional testimony about the Trump Tower Moscow project was designed to minimize connections between the president and Russia and to help limit the congressional and DOJ Russia investigations, a goal that was in the president's interest, as reflected by the president's own statements. During and after the campaign, the president made repeated statements that he had, quote, no business in Russia, and said that there were, quote, no deals that could happen in Russia because we stayed away. As Cohn knew, and as he recalled communicating to the president during the campaign, Cohn's pursuit of the Trump Tower Moscow project cast doubt on the accuracy or completeness of these statements. In connection with his guilty plea, Cohn admitted that he had multiple conversations with candidate Trump to give him status updates about the Trump Tower Moscow project, that the conversations continued through at least June 2016, and that he discussed with Trump possible travel to Russia to pursue the project. The conversations were not offhand, according to Cohn, because the project had the potential to be so lucrative. In addition, text messages to and from Cohn and other records further establish that Cohn's efforts to advance the project did not end in January 2016, and that in May and June 2016, Cohn was considering the timing for possible trips to Russia by him and Trump in connection with the project. The evidence could support an inference that the president was aware of these facts at the time of Cohn's false statements to Congress. Cohn discussed the project with the president in early 2017 following media inquiries. Cohn recalled that on September 20th, 2017, the day after he released to the public his opening remarks to Congress, which said the project was terminated in January of 2016, the president's personal counsel told him the president was pleased with what Cohn had said about Trump Tower Moscow. And after Cohn's guilty plea, the president told reporters that he had ultimately decided not to do the project, which supports the inference that he remained aware of his own involvement in the project and the period during the campaign in which the project was being pursued. The president's public remarks following Cohn's guilty plea also suggest that the president may have been concerned about what Cohn told investigators about the Trump Tower Moscow project. At the time the president submitted written answers to questions from this office about the project and other subjects, the media had reported that Cohn was cooperating with the government, but Cohn had not yet pleaded guilty to making false statements to Congress. Accordingly, it was not publicly known what information about the project Cohn had provided to the government. In his written answers, the president did not provide details about the timing and substance of his discussions with Cohen about the project, and gave no indication that he had decided to no longer pursue the project. Yet, after Cohen pleaded guilty, the president publicly stated that he had personally made the decision to abandon the project. The president then declined to clarify the seeming discrepancy to our office or answer additional questions. The content and timing of the president's provision of information about his knowledge and actions regarding the Trump Tower Moscow project is evidence that the president may have been concerned about the information that Cohen could provide as a witness. The president's concern about Cohen cooperating may have been directed at the Southern District of New York investigation into other aspects of the president's dealings with Cohen rather than an investigation of Trump Tower Moscow. There is also some evidence that the president's concern about Cohen cooperating was based on the president's stated belief that Cohen would provide false testimony against the president in an attempt to obtain a lesser sentence for his unrelated criminal conduct. The president tweeted that Manafort, unlike Cohen, refused to rake and make up stories in order to get a deal. And after Cohen pleaded guilty to making false statements to Congress, the president said, quote, "What Cohen's trying to do is get a reduced sentence, so he's lying about a project that everybody knew about," unquote. But the president also appeared to defend the underlying conduct, saying, quote, "Even if Cohen was right, it doesn't matter because I was allowed to do whatever I wanted during the campaign," unquote. As discussed above, there is no evidence that the president knew that Cohen had made false statements about the Trump Tower Moscow project, and that Cohen did so to protect the president and minimize the president's connections to Russia during the campaign.
My name is Bruno Oliver, and I am an actor and a theater maker around town. Finally, the president's statements insinuating that members of Cohen's family committed crimes after Cohen began cooperating with the government could be viewed as an effort to retaliate against Cohen and chill further testimony adverse to the president by Cohen or others. It is possible that the president believes, as reflected in his tweets, that Cohen made up stories in order to get a deal for himself and get his wife and father-in-law off scot-free. It is also possible that the president's mention of Cohen's wife and father-in-law were not intended to affect Cohen as a witness, but rather were part of a public relations strategy aimed at discrediting Cohen and deflecting attention away from the president on Cohen-related matters. But the president's suggestion that Cohen's family members committed crimes happened more than once, including just before Cohen was sentenced, at the same time as the president stated that Cohen, quote, "should, in my opinion, serve a full and complete sentence," unquote, and again just before Cohen was scheduled to testify before Congress. The timing of these statements supports an inference that they were intended, at least in part, to discourage Cohen from further cooperation. L. Overarching factual issues. Although this report does not contain a traditional prosecution decision or declination decision, the evidence supports several general conclusions relevant to analysis of the facts concerning the president's course of conduct. 1. 3 features of this case render it atypical compared to the heartland obstruction of justice prosecutions brought by the Department of Justice. First, the conduct involved actions by the president. Some of the conduct did not implicate the president's constitutional authority and raises garden variety obstruction of justice issues. Other events we investigated, however, drew upon the president's Article II authority, which raised constitutional issues that we addressed in Volume 2, Section 2B. A factual analysis of that conduct would have to take into account both that the president's acts were facially lawful and that his position as head of the executive branch provides him with unique and powerful means of influencing official proceedings, subordinate officers, and potential witnesses. Second, many obstruction cases involve the attempted or actual cover-up of an underlying crime. personal criminal conduct can furnish strong evidence that the individual had an improper obstructive purpose, see e.g. United States versus Willoughby. But proof of such crimes is not an element of an obstruction offense, see United States v. Greer, stating in applying the obstruction sentencing guideline that quote, obstruction of a criminal investigation is punishable even if the prosecution is ultimately unsuccessful or even if the investigation ultimately reveals no underlying crime, unquote. Obstruction of justice can be motivated by a desire to protect non-criminal personal interests, to protect against investigations where underlying criminal liability falls into a gray area, or to avoid personal embarrassment. The injury to the integrity of the justice system is the same, regardless of whether a person committed an underlying wrong. In this investigation, the evidence does not establish that the president was involved in an underlying crime related to the Russian election interference, but the evidence does point to a range of other personal motives animating the president's conduct. These include concerns that continued investigation would call into question the legitimacy of his election and potential uncertainty about whether certain events, such as advance notice of WikiLeaks' release of hacked information on June 9, 2016, meeting between senior campaign officials and Russians, could be seen as criminal activity by the president, his campaign, or his family. Third, many of the president's acts directed at witnesses, including discouragement of cooperation with the government and suggestions of possible future pardons, occurred in public view. While it may be more difficult to establish that public-facing acts were motivated by a corrupt intent, the president's power to influence actions, persons, and events is enhanced by his unique ability to attract attention through the use of mass communications. And no principle of law excludes public acts from the scope of obstruction statutes. If the likely effect of the acts is to intimidate witnesses or alter their testimony, the justice system's integrity is equally threatened. Although the events we investigated involved discrete acts, for example, the president's statement to Comey about the Flynn investigation, his termination of Comey, and his efforts to remove the special counsel, it is important to view the president's pattern of conduct as a whole. That pattern sheds light on the nature of the president's acts and the inferences that can be drawn about his intent. Our investigation found multiple acts by the president that were capable of exerting undue influence over law enforcement investigations, including the Russian interference and obstruction in investigations. The incidents were often carried out through one-on-one meetings in which the president sought to use his official power outside of usual channels. These actions ranged from efforts to remove the special counsel and to reverse the effects of the Attorney General's recusal, to the attempted use of official power to limit the scope of the investigation, to direct and indirect contacts with witnesses with the potential to influence the testimony. Viewing the acts collectively can help to illuminate their significance. For example, the president's direction to McGahn to have the special counsel removed was followed almost immediately by his direction to Lewandowski to tell the Attorney General to limit the scope of the Russian investigation to prospective election interference only, a temporal connection that suggests that both acts were taken with a related purpose in respect to the investigation. The president's efforts to influence the investigation were mostly unsuccessful, but that is largely because the persons who surrounded the president declined to carry out orders or accede to his requests. Comey did not end the investigation of Flynn, which ultimately resulted in Flynn's prosecution and conviction for lying to the FBI. McGahn did not tell the acting attorney general that the special counsel must be removed, but was instead prepared to resign over the president's order. Lewandowski and Dearborn did not deliver the president's message to Sessions that he should confine the Russian investigation to future election meddling only. And McGahn refused to recede from his recollections about events surrounding the president's direction to have the special counsel removed, despite the president's multiple demands that he do so. Consistent with that pattern, the evidence we obtained would not support potential obstruction charges against the president's aides and associates beyond those already filed. In considering the full scope of the conduct we investigated, the president's action can be divided into two distinct phases, reflecting the possible shift in the president's motives. In the first phase, before the president fired Comey, the president had been assured that the FBI had not opened an investigation of him personally. The president deemed it critically important to make public that he was not under investigation, and he included that information in his termination letter to Comey after other efforts to have that information disclosed were unsuccessful. Soon after he fired Comey, however, the president became aware that the investigators were conducting an obstruction of justice inquiry into his own conduct. That awareness marked a significant change in the president's conduct and the start of a second phase of action. The president launched public attacks on the investigation and individuals involved in it who could possess evidence adverse to the president, while in private, the president engaged in a series of targeted efforts to control the investigation. For instance, the president attempted to remove the special counsel. He sought to have Attorney General Sessions unrecuse himself and limit the investigation. He sought to prevent public disclosure of information about the June 29, 2016 meeting between the Russian and campaign officials, and he used public forums to attack potential witnesses who might offer adverse information and to praise witnesses who declined to cooperate with the government. Judgments about the nature of the president's motives during each phase would be informed by the totality of the evidence.
My name is Bruce Lemon. I'm a theater artist representing Cornerstone Theater Company, Watts Village, and myself. Legal defenses to the application of obstruction of justice statutes to the president. The president's personal counsel has written to this office to advance the statutory and constitutional defenses to the potential application of the obstruction of justice statutes to the president's conduct. As a statutory matter, the president's counsel has argued that a core obstruction of justice statute, 18 U.S.C. 1512, does not cover the president's actions. As a constitutional matter, the president's counsel argued that the president cannot obstruct justice by exercising his constitutional authority to close Department of Justice investigations or terminate the FBI director. Under that view, any statute that restricts the president's exercise of these powers would impermissibly intrude on the president's constitutional role. The president's counsel has conceded that the president may be the subject to criminal laws that do not directly involve exercises of this Article JI authority, such as laws prohibiting bribing witnesses or suborning perjury. But counsel has made a categorical argument that the president's exercise of his constitutional authority here to terminate an FBI director and to close investigations cannot constitutionally constitute obstruction of justice. In analyzing counsel's statutory arguments, we concluded that the president's proposed interpretation of Section 1512C2 is contrary to the litigating position of the Department of Justice and is not supported by principles of statutory construction. As for the constitutional arguments, we recognize that the Department of Justice and the courts have not definitively resolved these constitutional issues. We therefore analyze the president's position through the framework of Supreme Court precedent addressing the separation of powers. Under that framework, we concluded Article 2 of the Constitution does not categorically and permanently immunize the president from potential liability for the conduct that we investigated. Rather, our analysis led us to conclude that the obstruction of justice statutes can validly prohibit a president's corrupt efforts to use his official powers to curtail, end, or interfere with an investigation. Statutory defenses to the application of obstruction of justice provisions to the conduct under an investigation. The obstruction of justice statute most readily applicable to our investigation is 18 U.S.C. 1512 C2, Section 1512C provides, whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both. The Department of Justice has taken the position that Section 1512C2 states a broad, independent, and unqualified prohibition on obstruction of justice. While defendants have argued that subsection C2 should be read to cover only acts that would, in 1512C2 confirms that its sweep is not tethered to Section 1512C1, courts have so interpreted it. Its history does not counsel otherwise, and no principle of statutory construction dictates a contrary view. On its face, therefore, Section 1512C2 applies to all corrupt means of obstructing a proceeding, pending or contemplated, including by improper exercises of official power. In addition, other statutory provisions that are potentially applicable to certain conduct we investigated broadly prohibit obstruction proceedings that are pending before courts, grand juries, and Congress. Congress has also specifically prohibited witness tampering. Section 1512C2 prohibits a broad range of obstructive acts. Several textual features of Section 1512C2 support the conclusion that the provision broadly prohibits corrupt means of obstructing justice and is not limited by the more specific prohibitions of Section 115.2C1, which focuses on evidence impairment. First, the text of Section 1512C2 is unqualified. It reaches acts that obstruct, influence, or impede any official proceeding when committed corruptly. Nothing in Section 1512C2's text limits the provision to acts that would impair the integrity or availability of evidence for use in an official proceeding. In contrast, Section 1512C1 explicitly includes the requirement that the defendant act with the intent to impair the object's integrity or availability for use in an official proceeding, a requirement that Congress also included in two other sections of 1512. C. Use of physical force with intent to cause a person to destroy an object. With intent to impair the integrity or availability of the object for use in an official proceeding, use of intimidation, threats, corrupt persuasion, or misleading conduct with intent to cause a person to destroy an object, with intent to impair the integrity or availability of the object for use in an official proceeding. But no comparable intent or conduct element focused on evidence impairment appears in Section 1512C2. The intent element in Section 1512C2 comes from the word corruptly. See example, United States versus McKibbins. The intent element is important because the word corruptly is what serves to separate criminal and innocent acts of obstruction. Internal quotation marks omitted. The conduct element in Section 1512C2 is obstructing, influencing, or impeding a proceeding. Congress is presumed to have acted intentionally in the disparate inclusion and exclusion of evidence impairment language. See Lauren versus United States. When Congress includes particular language in one section of a statute, but omits it in another, let alone the very next provision, this court presumes that Congress intended a different meaning. Second, the structure of Section 1512 supports the conclusion that Section 1512C2 defines an independent offense. Section 1512C2 delineates a complete crime with different elements from Section 1512C1, and each subsection of 1512C contains its own attempt prohibition, underscoring that they are independent prohibitions. The two subsections of Section 1512C are connected by the conjunction or indicating that each provides an alternative basis for crime liability. See Lauren. Ordinary use of or is almost always disjunctive. That is, the words it connects are to be given separate meanings. Internal quotation marks omitted. In Lauren, for example, the Supreme Court relied on the use of the word or to hold that adjacent and overlapping subsections of the bank fraud statute, USC 1344. State distinct offenses, and that subsection 1344-2 therefore should not be interpreted to contain an additional element specified only in section 1344I. See also Shaw versus United States. And here, as in Lauren, section 1512C's two clauses have separate numbers, line breaks before, between, and after them, and equivalent indentation, thus placing the clauses visually on an equal footing and indicating that they have separate meanings. Third, the introductory word otherwise in section 1512C2 signals that the provision covers obstructive acts that are different from those listed in section 1512C1. The purpose of the word otherwise in section 1512C2 is therefore to clarify that the provision covers obstructive acts other than destruction of physical evidence with the intent to impair its integrity or availability, which is the conduct addressed in section 1512C1. The word otherwise does not signal that 1512C2 has less breadth in covering obstructive conduct than the language of the provision implies. 2. Judicial decisions support a broad reading of section 1512C2. Courts have not limited section 1512C2 to conduct that impairs evidence, but instead have read it to cover obstructive acts in any form. As one court explained, this expansive subsection operates as a catch-all to cover otherwise obstructive behavior that might not constitute a more specific offense like document destruction, which is listed in C1, United States versus Volpedesto, some quotation marks omitted. For example, in United States versus Ring, the court rejected the argument that 1512C2's reference to conduct that otherwise obstructs, influences, or impedes any official proceeding is limited to conduct that is similar to the type of conduct proscribed by subsection C1, namely, conduct that impairs the integrity or availability of records, documents, or other objects for use in an official proceeding. In ID at 224, the court explained that the meaning of 1512C2 is plain on its face, ID alterations in original, and courts have upheld convictions under section 1512C2 that did not involve evidence impairment, but instead resulted from the conduct that more broadly thwarted arrests and investigations. See example, United States versus Martinez. Police officer tipped off subjects about insurance of arrest warrants before outstanding warrants could be executed by, therefore potentially interfering with an ongoing grand jury proceeding. United States versus Arnsfield. Officer disclosed existence of an undercover investigation on his target. United States versus Phillips, 10th Circuit, 2009. Defendant disclosed identity of an undercover officer, thus preventing him from making controlled purchases from methamphetamine dealers. Those cases illustrate that section 1512C2 applies to corrupt acts, including by public officials that frustrate the commencement or conduct of a proceeding, and not just acts that make evidence unavailable to impair its integrity.
I can top that. Oh, yeah. Standing ovation. Okay, I'm Ken Werther. I am a publicist. Okay, we're going to keep going with this. Section 1512C2's breadth is enforced by the similarity of its language to the Omnibus Clause of 18 U.S.C. 1503, which covers anyone who, quote, corruptly obstructs or impedes or endeavors to influence, obstruct, or impede the due administration of justice. That clause of Section 1503 follows two more specific clauses that protect jurors, judges, and court officers. The Omnibus Clause has nevertheless been construed to be, quote, far more general in scope than the earlier clauses of the statute, close quote. United States versus Aguilar, 515 U.S. 593, 599, 1995. The Omnibus Clause is essentially a catch-all provision which generally prohibits conduct that interferes with the due administration of justice. United States versus Brenson, Courts have accordingly given it a non-restrictive reading, United States versus Kumar. As one court has explained, the Omnibus Clause prohibits acts that are similar in result rather than manner to the conduct described in the first part of the statute, United States versus Howard. While the specific clauses forbid certain means of obstructing justice, the Omnibus Clause aims at obstruction of justice itself, regardless of the means used to reach that result, as in collecting cases. Given the similarity of Section 1512C2 to Section 1503's Omnibus Clause, Congress would have expected Section 1512C2 to cover acts that produced a similar result to the evidence impairment provisions, i.e., the result of obstructing justice rather than covering only acts that were similar in manner. Read this way, Section 1512C2 serves a distinct function in the federal obstruction of justice statutes. It captures corrupt conduct other than document destruction that has the natural tendency to obstruct contemplated as well as pending proceedings. Section 1512C2 overlaps with other obstruction statutes, but it does not render them superfluous. Section 1503, for example, which covers pending grand jury and judicial proceedings, and Section 1505, which covers pending administrative and congressional proceedings, reach, quote, endeavors to influence, obstruct, or impede, close quote, the proceedings, a broader test for, I've never known this word, inchoate violations than Section 1512C2's attempt standard, which requires a substantial step towards a completed offense, and 18 U.S.C. 1519, which prohibits destruction of documents or records in contemplation of an investigation or proceeding, does not require the nexus showing under Aguilar, which Section 1512C2 demands. The existence of even substantial overlap is not uncommon in criminal statutes. Loughran, 573 U.S. at 359, number 4, see Shaw, 137, South Court at 458 to 469, Aguilar, 515 U.S. at 616, Scalia, dissenting, quote, the fact that there is now some overlap between 1503 and 1512 is no more intolerable than the fact that there is some overlap between the Omnibus Clause of 1503 and the other provisions of 1503 itself. But given that sections 1503, 1505, and 1519 each reach conduct that section 15C2 does not, the overlap provides no reason to give section 1512C2 an artificially limited construction. See Shaw, 137 South Court at 469. Yeah. And we wonder why we have these problems. The legislative history of section 1512C2 does not justify narrowing its text. Given the straightforward statutory command in section 1512C2, there is no reason to resort to legislative history. United States versus Gonzalez, 52 U.S. 1, 6, 1997. In any event, the legislative history of section 1512C2 is not a reason to impose extra-textual limitations on its reach. Congress enacted section 1512C2 as part the Sarbanes-Oxley Act of 2002. The relevant section of the statute was entitled Tampering with a Record or Otherwise Impeding an Official Proceeding. 116 Statute 807, emphasis added. That title indicates that Congress intended the two clauses to have independent effect. Section 1512C was added as a floor amendment in the Senate and explained as closing a certain loophole with respect to document shredding. But those explanations do not limit the enacted text. The floor statements thus cannot detract from the meaning of the enacted text. That principle has particular force where one of the proponents of the amendment to Section 1512 introduced his remarks as only, quote, briefly elaborating on some of the specific provisions contained in this bill. Indeed, the language Congress used in Section 1512C2 prohibiting, quote, corruptly obstructing, influencing, or impeding any official proceeding, close quote, or attempting to do so, parallels a provision that Congress considered years earlier in a bill designed to strengthen protections against witness tampering and obstruction of justice. While the earlier provision is not a direct antecedent of Section 12C2, Congress's understanding of the broad scope of the earlier provision is instructive, recognizing that the proper administration of justice may be impeded or thwarted by a variety of corrupt methods limited only by the imagination of the criminally inclined. Congress considered a bill that would have amended Section 1512 by making it a crime, inter alia, when a person, quote, corruptly influences, obstructs, or impedes the enforcement and prosecution of federal law, administration of a law under which an official proceeding is being or may be conducted, or the exercise of a federal legislative power of inquiry.
Hi there, I'm Bernard Addison. I am an actor and instructor. Thank you. Thank you. The Senate committee explained that the purpose of preventing an obstruction or miscarriage of justice cannot be fully carried out by a simple enumeration of the commonly prosecuted obstruction offenses. There must also be protection against the rare type of conduct that is the product of the inventive criminal mind, and which also thwarts justice. The report gave examples of conduct, quote, actually prosecuted under the current residual clause in 18 U.S.C. 1503, which would probably not be covered in this series of provisions without a residual clause, unquote. One prominent example was, quote, a conspiracy to cover up the Watergate burglary and its aftermath by having the Central Intelligence Agency seek to interfere with an ongoing FBI investigation of the burglary, citing United States versus Halderman. The report therefore indicates that congressional awareness not only that the residual clause language resembling Section 1512C2 broadly covers a wide variety of obstructive conduct, but also that such language reaches the improper use of governmental processes to obstruct justice, specifically the Watergate cover-up orchestrated by White House officials, including the president himself. General principles of statutory construction do not suggest that Section 1512C2 is inapplicable to the conduct in this investigation. The requirement of fair warning in criminal law, the interest in avoiding due process concerns in potentially vague statutes, and the rule of lenity do not justify narrowing the reach of Section 1512C2's text. As with other criminal laws, the Supreme Court has, quote, exercised restraint, unquote, in interpreting obstruction of justice provisions, both out of respect for Congress's role in defining crimes and in the interest of providing individuals with fair warning of what a criminal statute prohibits. Marinello versus United States Aguilar. In several obstruction cases, the court has imposed a nexus test that requires that the wrongful conduct targeted by the provision be sufficiently connected to an official proceeding to ensure the requisite culpability. To satisfy the nexus requirement, the government must show as an objective matter that a defendant acted, quote, in a manner that is likely to obstruct justice, unquote, such that the statute, quote, excludes defendants who have an evil purpose, but use means that would only unnaturally and improbably be successful, unquote. The government must also show as a subjective matter that the actor, quote, contemplated a particular foreseeable proceeding, unquote. Those requirements alleviate fair warning concerns by ensuring that obstructive conduct has a close enough connection to existing or future proceedings to implicate the dangers targeted by the obstruction laws, and that the individual actually has the obstructive result in mind. Courts also seek to construe statutes to avoid due process vagueness concerns. See, for example, McDonald versus United States. Vagueness doctrine requires that a statute define a crime, quote, with sufficient definiteness that ordinary people can understand what conduct is prohibited, quote, and in a manner that does not encourage arbitrary and discriminatory enforcement, unquote. The obstruction statute's requirement of acting corruptly satisfies that test. Acting corruptly within the means of 1512c2 means acting with an improper purpose and to engage in conduct knowingly and dishonestly with the specific intent to subvert, impede, or obstruct the relevant proceeding. United States versus Gordon, some quotation marks omitted. The majority opinion in Aguilar did not address the defendant's vagueness challenge to the word corruptly, 515 U.S. at 600 N1, but Justice Scalia's separate opinion did reach that issue and would have rejected the challenge. Statutory language need not be colloquial, Justice Scalia explained, and the term corruptly in criminal laws has a long-standing and well-accepted meaning. It denotes an act done with an intent to give some advantage inconsistent with official duty and the rights of others, unquote. Justice Scalia added that, quote, in the context of obstructing jury proceedings, any claim of ignorance of wrongdoing is incredible, unquote. Lower courts have also rejected vagueness challenges to the word corruptly. See, for example, United States versus Edwards. This well-established intent standard precludes the need to limit the obstruction statutes to only certain kinds of inherently wrongful conduct. Finally, the rule of lenity does not justify treating Section 1512c2 as a prohibition on evidence impairment as opposed to an omnibus clause. The rule of lenity is an interpretive principle that resolves ambiguity in criminal laws in favor of the less severe construction. Cleveland versus United States. Quote, as the court has repeatedly emphasized, however, the rule of lenity applies only if, after considering text, structure, history, and purpose, there remains a grievous ambiguity or uncertainty in the statute such that the court must simply guess as to what Congress intended, unquote. Eberniski versus United States. The rule has been cited, for example, in adopting a narrow meaning of tangible object in an obstruction statute when the prohibition's title, history, and list of prohibited acts indicated a focus on destruction of records. See Yates versus United States, plurality opinion, interpreting tangible object in the phrase record, document, or tangible object in 18 U.S.C. 1519 to mean an item capable of recording or preserving information. Here, as discussed above, the text structure and history of Section 1512c2 leaves no grievous ambiguity about the statute's meaning. Section 1512c2 defines a structurally independent general prohibition of obstruction of official proceedings. Other obstruction statutes might apply to the conduct in this investigation, regardless whether Section 1512c2 covers all corrupt acts that obstruct, influence, or impede pending or contemplated proceedings. Other statutes would apply to such conduct in pending proceedings, provided that the remaining statutory elements are satisfied. As discussed above, the Omnibus Clause in 18 U.S.C. 1503a applies generally as obstruction of pending judicial and grand proceedings, And Section 1505 broadly criminalizes obstructive conduct aimed at pending agencies and congressional proceedings. Finally, 18 U.S.C. 1512b3 criminalizes tampering with witnesses to prevent the communication of information about a crime to law enforcement. The nexus inquiry articulated in Aguilar that an individual has knowledge that his actions are likely to affect the judicial proceeding, 515 U.S. at 599, does not apply to Section 1512.6.3, see United States versus Byrne, 435 FD 3, I6, 2425, First Circuit, 2006. The nexus inquiry turns instead on the actor's intent to prevent communications to a federal law enforcement official. See Fowler versus United States. In sum, in light of the breadth of Section 1512C2 and the other obstruction statutes, an argument that the conduct at issue in this investigation falls outside the scope of the obstruction laws lacks merit. B, constitutional defenses to applying obstruction of justice statutes to presidential conduct. The president has broad discretion to direct criminal investigations. The Constitution vests that executive power in the president enjoins him to take care that the laws be faithfully executed. U.S. Constitution, Article 1. Those powers and duties form the foundation of prosecutorial discretion. The president also has authority to appoint officers of the United States and to remove those to whom he has appointed. U.S. Constitution, Article 2, granting authority to the president to appoint all officers with the advice and consent of the Senate, but providing that Congress may vest the appointment of inferior officers in the president alone, the heads of departments, or the courts of law. See also Free Enterprise Fund versus Public Company Accounting Oversight Board, describing removal authority as flowing from the president's responsibility to take care that the laws be faithfully executed. Thank you.
My name is Adam Leibowitz Lockhard. I am an actor and an Elizabeth Warren fan. So. Although the president, and I'm going to be reading the final pages up until the conclusion. So, well done. Although the president has broad authority under Article 2, that authority coexists with Congress's Article 1 power to enact laws that protect congressional proceedings, federal investigations, the courts, and grand juries against corrupt efforts to undermine their functions. Usually, those constitutional powers function in harmony, with the president enforcing the criminal laws under Article IT to protect against corrupt, obtrusive acts. But when the president's official actions come into conflict with the prohibitions in the obstruction statutes, any congressional tension is reconciled through separation of powers analysis. The president's counsel has argued that, quote, the president's exercise of his constitutional authority to terminate an FBI director and to close investigations cannot constitutionally constitute obstruction of just use. 1086. As noted above, no Department of Justice position or Supreme Court precedent directly resolved this issue. We did not find counsel's contention, however, to accord with our reading of the Supreme Court authority addressing separation of powers issues. Applying the court's framework for analysis, we concluded that Congress can validly regulate the president's exercise of official duties to prohibit actions motivated by a corrupt intent to obstruct justice. The limited effect on presidential power that results from that restriction would not impermissibly undermine the president's ability to perform his Article 2 functions. The requirement of a clear statement to apply statutes to presidential conduct does not limit the obstruction statutes. Before addressing Article 2 issues directly, we consider one threshold statutory construction principle that is unique to the presidency. Quote, the principle that general statutes must be read as not applying to the president if they do not expressly apply where applicable would arguably limit the president's constitutional role. This, quote, clear statement rule, has its source in two principles. Statutes should be construed to avoid serious constitutional questions, and Congress should not be assumed to have altered the constitutional separation of powers without clear assurance that it intended that result. The Supreme Court has applied that clear statement rule in several cases. In one leading case, the court construed the Administrative Procedure Act. The court explained that it, quote, would require an express statement by Congress before assuming it intended the president's performance of his statutory duties to be reviewed for abuse of discretion. In another case, the court interpreted the word utilized in Federal Advisory Committee Act, FACA, to apply only to the use of advisory committees established directly or indirectly by the government, thereby excluding the American Bar Association's advice to the Department of Justice about federal judicial candidates. The court explained that a broader interpretation of the term utilized in FACA would raise serious questions whether the statute, quote, infringed unduly on the president's Article II power to nominate federal judges and violated the doctrine of separation of powers. Another case found that an established canon of statutory construction applied with special force to provisions that would impinge on the president's foreign affairs powers if construed broadly. The Department of Justice has relied on this clear statement principle to interpret certain statutes as not applying to the president at all, similar to the approach taken in Franklin. Other OLC opinions interpret statutory text not to apply to certain presidential or executive actions because of constitutional concerns. Limitation on the use of appropriated funds for certain lobbying programs found inapplicable to certain communications by the president and executive officials. But OLC has also recognized that this clear statement rule, quote, does not apply with respect to a statute that raises no separation of powers questions were it to be applied to the president, quote, quote, such as the federal bribery statute. OLC explained that, quote, application of it raises no separation of powers question, let alone a serious one, because the Constitution confers no power in the president to receive bribes. In support of that conclusion, OLC noted constitutional provisions that forbid increases to the president's compensation while in office, quote, which is what a bribe would function to do, close quote. Under OLC's analysis, Congress can permissibly criminalize certain obstructive conduct by the president, such as suborning perjury, intimidating witnesses, or fabricating evidence, because those prohibitions raise no separation of powers questions. The Constitution does not authorize the president to engage in such conduct, and those actions would transgress the president's duty to, quote, take care that the laws be faithfully executed. United States Constitution, Article 2. In view of those clearly permissible applications of the obstruction statutes to the president, Franklin's holding that the president is entirely excluded from a statute absent a clear statement would not apply in this context. A more limited application of a clear statement rule to exclude from the obstruction statutes only certain acts by the president, for example, removing prosecutors or ending investigations for corrupt reasons, would be difficult to implement as a matter of statutory interpretation. It is not obvious how a clear statement rule would apply to an omnibus provision like Section 1512(c)(2), to exclude correctly motivated obstructive acts only when carried out in the president's conduct of office. No statutory term could easily bear that specialized meaning. For example, the word corruptly has a well-established meaning that does not exclude exercises of official power for corrupt ends. Indeed, an established definition states that corruptly means action with an intent to secure an improper advantage, quote, inconsistent with official duty and the rights of others, close quote. and it would be contrary to ordinary rules of statutory construction to adopt an unconventional meaning of a statutory term only when applied to the president. Nor could such an exclusion draw on a separate and established background interpretive presumption, such as the presumption against extraterritorially applied in sale. The principle that courts will construe a statute to avoid serious constitutional questions is not a license for the judiciary to rewrite language enacted by the legislature. When a proposed construction would thus function as an extra-textual limit on a statute's compass, thereby preventing the statute, quote, from applying to a host of cases falling within its clear terms, close quote, it is doubtful that the construction would reflect Congress's intent. That is particularly so with respect to obstruction statutes, which, quote, have been given a broad and all-inclusive meaning. Accordingly, since no established principle of interpretation would exclude the presidential conduct, we have investigated from statutes such as sections 1503, I-505, I-512B, and I-1512C2, we proceed to examine the separation of powers issues that could be raised as an Article II defense to the application of those statutes. Stephen Sachs.
Conclusion. Because we determined not to make a traditional prosecutorial judgment, we did not draw ultimate conclusions about the president's conduct. The evidence we obtained about the president's actions and intent presents difficult issues that would need to be resolved if we were making a traditional prosecutorial judgment. At the same time, if we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the president committed a crime, it also does not exonerate him. And that concludes our Mueller report readathon. Let's do it all again, shall we? Okay. After 15 hours, more than 90 readers and hundreds of people who came through these doors, came and went throughout the day, all day and all night, we actually have a couple who have been here with us all day and all night for all 15 hours. And let's give a big Fountain Theater round of applause for Steve Warheit and Jean Christensen. We're true American, true citizens. And I want to thank the Fountain staff who have also been here all day and all night, making sure that everything ran so smoothly and so brilliantly. Simon Levy, James Bennett, Scott Toomey, Terry Roberts, Barbara Goodhill, Melina Young, Richard Horton, Jose Lamelli, Justin Dunlap, and Abby Guerra. And don't forget that the Odyssey Theater will be holding its own Mueller Report readathon in 2 parts on July 22nd and 23rd. So from the Fountain Theater, good night, sleep well, because tomorrow is another day.